It was prominent attorney-at-law Nigel Hughes that brought to the fore that the opposition needed 34 votes instead of 33 to have its no-confidence motion against the government validly passed in the National Assembly, just days after the motion was carried in the House. In the High Court, the Chief Justice ruled that the 33 votes were enough in the 65-seat National Assembly. That ruling was overturned in the Appellate Court, validating Hughes' argument that he put forward in the public domain.
I'm happy that the view that I expressed was confirmed by the Court of Appeal in their decision. This is by no means the final stage. We have the Caribbean Court of Justice to proceed to. So this is an interim stage. You can say this is round 2, and we have the final round to go to.
In the ruling of the Court of Appeal, it was stated that an absolute majority and a simple majority is not the same. The term absolute majority was a fundamental component in the presentations of the government's legal team in the appeal court. But nowhere in Article 1066 is the term absolute majority mentioned. It states that the cabinet, including the president, shall resign if the government is defeated by the vote of a majority of all the elected members of the National Assembly on a vote of confidence.
Very rarely would you find a constitution that says absolute majority. Absolute majority is a concept, and the language that is used in Article 106.6, i.e. the majority of the elected members of the House, that identical phrase was used in the same term that came up, in the same article that came up in the third term case, the Cedric Richardson case. And that language indicates what an absolute majority is. You don't have to look for the word absolute. It is the language that is used in the Constitution, particularly in the context of the Constitution, to indicate what was intended.
In other parts of the Constitution, Hughes says a majority of members present and voting is referred to, which is a different type of majority, he explained.
That majority depends on a couple of things. One of them is people being present and there being a vote. That's what you would call a simple majority. So I think perhaps one of the areas of difficulty that people encountered is they said everybody turned up on the day of the no confidence vote, and therefore if you had one more than the other, then that's an absolute majority. And that highlights the point. The issue is not whether or not everybody turned up, because that's an issue of presence. Whether or not everybody turned up, the requirement to pass a no confidence vote is 34. So let's take a ridiculous example. 35 people turned up and 34 voted, it would have been valid. It's a completely different thing from people being present and voting. So an absolute majority is a legal formula which is determined and has no connection with presence, and it's pretty clearly defined as the requirement for the word absolute to be used. It's a legal term of art that indicates and differentiates different types of majority.
The majority issue should have been dealt with since 2014, according to Hughes.
The previous president had this opinion that said that the majority was 34, and it explained the basis upon which that majority was calculated. That president, from the time he received that opinion, would have been aware that there are people in the legal profession that would hold that view, even though he chose not to adopt it. And therefore, from 2014, he did not accept it. It doesn't mean that his refusal of that opinion, that he was correct. So we should have sorted this out in 2014. I wish President Ramatar had gone to court in 2014 and sought the court's guidance in 2014. We wouldn't be having this problem in 2018 and 2019. And perhaps the reason why I shared my view on Facebook is that it's difficult to watch your country head into another crisis, because that's what's going to happen. If somebody didn't raise it now, they would raise it later. Every time you have a single seat majority in the parliament, it will come up, and we cannot continue like Sisyphus to rehash the same arguments over and over again.
While the opposition is hopeful that the Caribbean Court of Justice will rule in its favor when the matter is taken there, Hughes says it would be highly inappropriate for him to make any comments on the possible outcomes of the matter at that forum. Handel Duncan, HGP Nightly News.